Hi guys, I've been hearing from a lot of you about your concerns about censorship and Justin Trudeau's Bill C-63, the online harms bill. Now, a lot of you, like me, you're really worried. To everyone who's written to your member of parliament asking them to stop and fix Bill C-63, thank you. And if you haven't, then you can still go to the ccf.ca/fix-C63, which I'll link to below, to send an automatic email to your member of parliament. We're really trying to get the problems with this bill, which are pretty significant, fixed. So because this bill does so many different things, I think that it's worth doing a deep dive into the real specifics and explain the problems in greater detail. And today I want to tell you about the problems with changes to the Canada Human Rights Act and the new civil remedy for hate speech. I hope you're ready. If you're new here, welcome. My name is Christine, and I'm the litigation director at the charity, the Canadian Constitution Foundation, a charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. Okay, so let's talk about the details of this new civil remedy. So I have an op-ed out in the National Post about the civil remedy, and I call it the zombie law because it was killed, came back, was killed again, and now it's back a third time. But this monster isn't, some spooky, creepy creature from a zombie movie with green oozing skin and long fingernails. Instead, it takes the form of a group of woke government bureaucrats investigating complaints about your speech, prosecuting you at their own little government tribunal, and ordering you to pay tens of thousands of dollars to people who don't like you or the things that you say or write. And that is how I describe the civil remedy. The civil remedy was previously Section 13 of the Canada Human Rights Act, and it was killed in 2014 by the Harper government after being badly abused. In 2021, the Trudeau government resurrected this civil remedy as Bill C-36, but it was killed again when the election was called. And now it's back for a third time as part of Bill C-63, and it is as dangerous to freedom of speech and freedom of the press as ever. The civil remedy for hate speech in Section 13 of the Canada Human Rights Act will result in self-censorship, intrude into press freedom, and result in frivolous complaints arising from online flame wars where the process itself becomes the punishment. And these frivolous complaints will clog up the already overburdened Human Rights Commission that's supposed to deal with serious and complex social problems like discrimination in transportation agencies or by government agencies. And this is all going to be supported by you and your taxpayer dollars. We know that this will be the outcome because we've already seen it play out in the past when this civil remedy used to exist. In 2007, the Canadian Human Rights Commission launched an investigation into Maclean's magazine based on complaints brought by the Canadian Islamic Congress alleging violations of hate speech prohibitions in Section 13 of the Canada Human Rights Act back then. The complaints were about a series of articles published by the magazine between 2005 and 2007, including, and probably most famously, a book excerpt of a book called America Alone by author Mark Steyn. Then in 2008, the Canadian Human Rights Commission started an investigation into Father Alphonse Devalque, who was a priest and pro-life activist who published in the monthly Catholic magazine Catholic Insight. And Father Devalque's problematic speech involved his opposition to same-sex marriage and quoting the Bible, the Catechism of the Catholic Church, and Pope John Paul II. Like the complaint against Steyn, the complaint against Father Devalque was made by a member of the public under the Canadian Human Rights Act and Section 13. Now, there was widespread outrage from the public over using the act this way to attack fairly mainstream views in mainstream publications. Up until this time, up until these types of complaints started, the Canadian Human Rights Act and this section had been largely uncontroversial. It had been mostly used to address the hate speech of skinheads and neo-Nazis and white supremacists. But suddenly the commissions were investigating complaints about speech that, as I said, was pretty close to mainstream views. Concerns like Islamist, jihadi violence, immigration, changing demographics, same-sex marriage, things like that. And further, the complaints were now being made against these mainstream publications like Maclean's, the Catholic Insight magazine, and in Alberta, the Western Standard. It was in this context of public outrage over the complaints process sort of being abused that Professor Richard Moon in 2008 was asked by the Canadian Human Rights Commission to write a report on the regulation of hate speech in the internet, focusing specifically on Section 13 of the Canada Human Rights Act. And Professor Moon, who is a progressive professor of law at University of Windsor, and his number one recommendation was that Section 13 of the Act be repealed. He found that the prohibition of a narrow category of extreme expression, hate speech, he said it fits very awkwardly within a human rights law that's concerned with the eradication of discrimination through education and conciliation. This Human Rights Tribunal is supposed to be concerned with discrimination against the public by Crown agencies or transportation, things like that. And that hate speech fits really strangely within that legislative framework. So Moon concluded that the Criminal Code hate speech provisions, which already existed, and by the way, still exist, they were enough. He took the position that state censorship of hate speech should be confined to a narrow category of extreme expression in the Criminal Code, which threatens, advocates, or justifies violence against members of an identifiable group. And those are all Criminal Code provisions we still have. So you might be wondering how things turned out for Stein and Father DeValk. Well, in 2008, the complaints against them were dismissed. They did not proceed to the tribunal. They just went through the investigation stage. But the investigation stage can still result in huge costs. Father DeValk spent about $20,000 in legal fees defending his expression as part of this investigation, even though it never got to the tribunal. And Mark Stein and Maclean's undoubtedly spent much more. The process became the punishment, even if the case doesn't proceed past an investigation. And what's important to know is that individuals who complain, the people who complained about Stein or about DeValk, or who might complain under the new bill C-63, well, they bear no costs associated with bringing a complaint, not even the cost of a lawyer. That is paid for by your tax dollars. If a complaint was dismissed as frivolous by the commission, the defendant couldn't even ask for costs the way they can in a civil court. Oh, and another thing to remember, the standard at these tribunals is much lower than the criminal law standard. So it doesn't resemble a criminal trial at all, where to prove there has been this hate speech, it's beyond a reasonable doubt. You need to prove it beyond a reasonable doubt, which is a high legal standard. This special little bureaucrat tribunal will have a lower civil standard. Now, I got some inside information because I am media. I'm the host of Canadian Justice, Canada's only national broadcast television program, which is dedicated to Canadian legal news and opinion. And because of this, I was able to attend the Department of Justice technical briefing for media. And at the technical briefing, the bureaucrats who came up with this law tried to reassure us that this version of Section 13 of the Canada Human Rights Act is actually much better than the old version. Under the new version, they say defendants can ask for costs if the complaint gets to the tribunal and if they find there has been an abusive process. But that doesn't save the defendant costs associated with the commission's investigation that may ultimately be dropped as frivolous and never proceeds to the tribunal the way it did in Father DeValk's case and in Mark Stein's case. And if it does proceed to the tribunal, abuse of process is such a high legal bar that it is essentially useless. Now, these bureaucrats also tried to convince the media that Section 13 is better because complaints don't automatically go to the tribunal. The commission will weed out frivolous complaints. But as I just said, the old Section 13 did that too. Those cases, Stein and Father DeValk's, they didn't make it to the tribunal. And the problem isn't just the offenses that get to the tribunal. No, Mark Stein, he was working with a big publication that defended him. But think about how this might apply to an individual like you if you don't have this whole infrastructure behind you that can pay your legal costs. The problem is the whole process, even if you never make it to tribunal. You know, you tweet something a little off color that makes someone who already doesn't like you mad. And so they complain at zero cost to the commission who investigates. And then in this media briefing, the bureaucrats really emphasize that their main concern is getting content taken down. So some bureaucrat at the commission contacts you about your naughty tweet. Do you get a lawyer to help with this investigation into your speech, an investigation that may end up in the tribunal? Or do you take the content down? Most people will probably find it's just easier to take the content down rather than fight the investigation. And then if it makes it to tribunal, fight the tribunal too, with this risk of penalties that they can impose. If you take the content down, the commission can then claim they aren't censoring you. You did this on your own. But it's the threat, it's the risk, it's the costs that are associated with all of this whole entire process. That is part of the censorship. And that threat, that risk, they are pretty serious. If the Human Rights Tribunal does find a violation under the proposed bill C-63, defendants can face penalties of up to $50,000 and up to $20,000 paid to complainants. The process actually incentivizes complaints at essentially zero cost. And if you do get to the tribunal, if you do decide to fight the investigation, I think that there should be real concerns that there will be big penalties under this new online harm bill. The Overton window has really shifted since 2007 when Father DeValk and Mark Stein had their investigations. And the definition of hatred, while theoretically narrow in scope, is inherently and unavoidably subjective. What the Canadian Human Rights Commission back in 2008 called hyperbole or polemical, colorful, or emphatic writing when describing what Stein had wrote, that writing could be viewed very differently by the government bureaucrats who staff this commission today. And what kind of people do you think are staffing these commissions? The problem is that these civil remedies for hatred are located within a law, a commission, and a whole bureaucracy that is obsessed and concerned with the advancement of social equality. So they will be looking at all of this speech that they're tasked now with investigating through that lens. And Professor Moon actually pointed out that placing hate speech awkwardly within that human rights framework will always make hate speech vulnerable to a more expansive interpretation, especially at the initial screening stage. So despite all of these, what I think are fatal flaws, this zombie law refuses to die. So please take the opportunity now to write to your member of parliament and explain why Bill C-63's plan to recreate a civil penalty for hate speech is as bad an idea today as it was when this law was first killed over a decade ago. I'm going to do a few more of these videos where I deep dive into the various problems in Bill C-63 and look at all of the different angles. So please subscribe to the channel so you don't miss the updates. And if you click that little bell icon below, it will let you know as soon as the new video is up. You can also subscribe to our email freedom updates so we let you know about developments in this law as it makes its way through Parliament. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.